Now, we will begin the first session under the topic of New Technologies and the Law of the Sea. Judge Roman KLEIN from International Tribunal for the Law of the Sea will moderate this session. He is online now. Judge KLEIN, are you there?
Yes, do you hear me?
Yes, thank you. The floor is yours.
Thank you, Professor KLEIN. Excellencies, dear colleagues, first of all, I would like to express my appreciation to the Korean Society of International Law and the Ministry of Foreign Affairs of the Republic of Korea for the invitation to moderate the session. It's a real privilege for me. I should add, of course, that I'm participating in the conference in my personal capacity. Let me briefly introduce our session. The interaction between technologies and law, the law of the sea in particular, is of course long-standing. To use the words of Judge Peg, historically, science and technology have been among the major drivers of the rule of the sea, of the law of the sea. Indeed, the law of the sea inevitably adjusts to technological progress. At the same time, nowadays, the existing legal regime, which embodies core, universally shared values, is an important factor in shaping new technologies and their uses. Our session will concentrate on two areas that are quite prominent in the modern discourse on technologies in the law of the sea context. Legal dimensions of A, autonomous vehicles, and B, deep seabed mining. News about autonomous vehicles or maritime autonomous ships start to come almost daily. For example, less than 2 weeks ago, we learned that the world's first autonomous, fully emissions-free cargo ship had been launched in Norway. The uses of maritime autonomous vehicles may be inter alia civil and military, peaceful and hostile, lawful and illegal. The law, both national and international, has to catch up with these developments. For example, in my home country, Russia, the regulations on trials and classification of the maritime autonomous vessels and guidelines on cyber safety of ships were adopted in 2020. We all know, of course, that the IMO, International Maritime Organization, has recently completed the assessment of existing IMO instruments to see how they might apply to maritime autonomous surface ships. The conclusion seems to be that the best way forward would be a holistic one, developing the so-called MASS code. It's worth noting here that a decade earlier than IMO, another UN specialized agency, International Civil Aviation Organization, started to discuss legal aspects of unmanned aviation, which is used, among other things, for multiple ocean-related activities. It would be interesting to see a kind of systemic assessment of the applicability of the UNCLOS, which, as was noted elsewhere before, was formulated in the context of manned vessels to autonomous vehicles. A lot has been said and is being said, including today, about the flexibility of the UNCLOS, its evolving character. Well, yes, of course, the convention is flexible and it's a living treaty. But I wonder whether the flexibility and the evolving nature of the convention is without limits. If it is, why would we need the implementation agreements or the new treaty on the on biodiversity. For me, every legal text has its limits. I don't believe that actually the UNCLOS applies to each and every issue or new issue arising with respect to the oceans. But let me get back to my short intro. There are already available academic writings on the legal aspects of the maritime autonomous vehicles, including by some participants of the conference. And I'm sure we will see more publications as the use of the autonomous vehicles in the ocean and above it will be growing. One day, a case implicating such a vehicle may be submitted to the UNCLOS compulsory dispute settlement procedures, to our tribunal, for example. Then those involved would certainly benefit from writings of the highly qualified publicists, to use the language of Article 38 of the Statute of the ICJ, as subsidiary means for the determination of the content of the applicable provisions of the Convention and other rules of international law. At least some of the above applies mutatis mutandis to the situation of mining in the area, the anticipation and reality of which was legally reflected in particular in the UNCLOS, its Part 11 implementation agreement, regulations on prospecting and exploration adopted by the International Seabed Authority, and the ICLS Seabed Disputes Chamber Advisory Opinion of 2011. This situation is also evolving. Thus, on the one hand, technology advancements makes the exploitation of the area's resources imminent. On the other, environmental concerns with respect to deep seabed mining are as high today as never before. As we know, the International Seabed Authority is still working on the draft rules relating to the exploitation of the area resources. Meanwhile, on the other hand, the 2 years period provided under the Part 11 implementation agreement for completing this work has been activated recently. And on the other hand, a resonant appeal for a moratorium for deep seabed mining was launched. Arguably, as it was noted elsewhere, the main test facing the industry is to create a sustainable system for deep seabed mining that satisfies humanity's increasing desire for raw materials while ensuring robust levels of marine environmental protection. Other major legal challenges in this field may be posed by the inevitable extensive involvement of private actors or entities in the exploitation of common heritage of mankind. So let me turn now to our distinguished speakers. There are some adjustments to the program indicated at the website of the conference. The program has evolved, so to say. Professor Natalie KLEIN will be the first speaker. Professor KLEIN is an Australian Research Council Future Fellow at the Faculty of Law and Justice of the University of New South Wales, Sydney. The paper she is presenting today is drawn from the ARC Discovery Project, which she calls with Associate Professor Douglas Guilfoyle, Associate Professor Saiful Karim, and Professor Rob McLaughlin. The project is examining the international law dimensions of maritime autonomous vehicles in relation to maritime security, and her presentation relies on some of that work. Professor KLEIN, in particular, is an author and co-author of several frequently referred to publications on the subject that she is going to address right now. Professor KLEIN, you have the floor, please.
Thank you very much, Judge Kolodkin, and I'd also like to extend my thanks to the Korean Ministry of Foreign Affairs, the Korean Society of International Law, and of course the International Tribunal for the Law of the Sea for the opportunity to be able to participate at the conference, albeit at a distance. I would love to be there in person, but perhaps an occasion will present itself in the future. In terms of what I'm going to be addressing today, just to give you an indication, let me see if I can advance my slides, there we are. I'm going to deal briefly just with some initial questions of definition and terminology when we're talking about maritime autonomous vehicles, because that in itself has consequences for the way that we understand the international law involved. And then given my focus on maritime security, I'm going to look in the first instance at when maritime autonomous vehicles are being used for policing activities, how that has implications for the right of visit and right of hot pursuit under UNCLOS, as well as what the implications might be for some of our multilateral treaties dealing with transnational crimes. And also I want to flip to the other side and think about what happens when criminals are using maritime autonomous vehicles and what challenges that poses to both international law and domestic law that we need to be thinking about. And just very briefly at the end, I'm going to signal some of the other concerns we might have in relation to maritime security, including the question of intelligence gathering, which will be dealt with in more detail by the following speaker. So when I'm talking about maritime autonomous vehicles, as I mentioned, there's this question of terminology that comes up, and we need to even think about something very rudimentary, which is how do we define vessels and ships? And from Andrew Norris's early work on this topic, once we start talking about maritime autonomous vehicles, we realize that we need to distinguish operationally between what are the vessel-like components that we're dealing with in the operation of ships and what are the crew-like components that we're dealing with. Now, when you start delving into the terminology in the literature, you can see immediately that there are many, many different acronyms with which you will be confronted. And that varies depending on whether you're talking about aerial, surface, or underwater vehicles. It also varies depending on whether you're talking about vehicles used in combat or not. If you're looking at scientists who are undertaking research, then they tend to refer to remotely operated vehicles. And then, as Claude mentioned at the outset, the International Maritime Organization has been looking into this question, and they refer to maritime autonomous surface ships. I was struck when I was looking at this terminology that it's really quite gendered in its naming. So that was one of the reasons that I preferred the idea of referring to maritime autonomous vehicles. But it did immediately also raise the question of, well, what do we mean by autonomous? So this is a question that has been dealt with by the IMO and also actually within the shipping industry. And so Lloyd's Register, for example, has sort of gone through and thought about different levels of autonomy. So we can perhaps think about 4 different levels of autonomy that we might be dealing with in this situation, and they vary quite considerably. So on the one hand, you might have a situation where a ship is still subject to manual navigation, but there are some automated processes and decisions that are being undertaken. Really, a lot of the technology that we're using today already involves automated processes. Just think about an automatic car, for example, changing gears for us already. But then we move to a next level where we have a remotely controlled vessel, which still has a crew on board. So the main operations of the ship's being managed remotely, but there's still some humans there who could potentially do things if they need to. Then we go to the next level where you have a remotely controlled vessel and there are no crew on board at all, but we've got someone operating the vessel in real time from shore. And then at the final end of the spectrum, we have the fully autonomous vessel. And so this is where the vessel has been crafted in such a way that there are algorithms that are set up in the working of the vessel. I'm not across all the technology involved, but the idea is that the vessel is programmed in such a way that it will respond to changing conditions automatically in its operations. So when we think about maritime autonomous vehicles, and particularly in relation to maritime security, we need to think about some of these different levels of autonomy that comes up. And then we have this question about, well, what is a vessel or what is a ship? UNCLOS doesn't define either of these terms. It tends to use vessel or ship interchangeably. The pictures that you see up here I have selected just to give you an idea of the size and variety that we are dealing with when we're talking about maritime autonomous vehicles. For those that are used for swarming exercises, of course those that are very large and are going to be potentially used for cargo shipping, down to very small vehicles that are being used for data collection. Of course, we've got the drones that you can see on the screen, and remotely controlled vehicles, and also some fairly high-tech military vessels coming along as well. So when we look at all of these, then we need to start thinking about, well, are these vessels or are these ships, and in what circumstances does it matter? Under the IMO conventions, it does in fact matter, because they have set up various definitions for ships. And so that has been part of the exercise at the IMO, going through and thinking about, well, what's going to constitute a ship for the purposes of these different conventions? And that obviously has consequences for maritime safety and feeds into some of our issues related to maritime security as well, especially when we start talking about the sewer convention or the coal regs. So we can potentially use those IMO conventions as well when we're trying to understand what might be a ship. We also have questions about whether a maritime autonomous vehicle constitutes a warship or not. And there, UNCLOS does provide us with a definition. And the definition of a warship, when you have a look at Article 29, does anticipate that there are humans involved, because it refers to that ship being under the command of an officer. And it also refers to being manned by a crew, which is under regular armed forces discipline. So we might have a situation where you have a remotely controlled vehicle, which is under the command of an officer, and perhaps those operating that remotely controlled vessel could be described as the crew that is sort of there operationalizing it. So maybe we can fit within the definition of warships. We can perhaps think that some flexibility is warranted in how we understand Article 29. For those of you familiar with the provision, you might know that the definition actually dates back centuries, because we adopted it as a response to privateering. So if you think that this definition of the warship was sort of developed as a response to privateering, we're not really triggering those sorts of concerns when we're trying to incorporate maritime autonomous vehicles within that definition. But there are consequences to whether we think of maritime autonomous vehicles in different situations as warships or not. First of all, of course, there's a question of immunity. And at least in terms of immunity, we know under Article 32 that even if maritime autonomous vehicle is not a warship, it's perhaps too autonomous to be considered under the command of an officer or manned by a crew, it could still be another government ship which is operated for non-commercial purposes. But it does still raise this question about, are they really ships in any event? On the screen here, you see a picture of a glider, and this was essentially the type of glider that was released from the USS Aldrich and then seized by the Chinese Navy at the end of 2016. So when you look at that, is that a ship that is subject to immunity under the convention, under customary international law? So there could be consequences there. And also we need to bear in mind that there's a difference for warships versus private vessels or other government ships when we think about responses to violations of the right of innocent passage. When a warship violates the right of innocent passage, they're asked to leave, whereas states can take necessary steps to prevent passage that is not innocent in relation to private vessels or other government ships potentially. Now, when we're thinking about the policing activities of maritime autonomous vehicles under UNCLOS, there's a range of different provisions to look at, and two I wanted to focus on in relation to policing activities relate to the right of visit under Article 110, and also the right of hot pursuit, which is set out in Article 111. Now, when you're looking at those two particular provisions, the first thing we need to consider is whether these maritime autonomous vehicles could potentially have these rights. Do these provisions apply to maritime autonomous vehicles? Well, again, this debate about whether they're warships or not comes up because the right of visit belongs to warships, whereas the right of hot pursuit is undertaken by the competent authorities of the coastal state. So there's a little bit more flexibility when we're talking about the right of hot pursuit in that context. But what you see up on screen here is a fire scout, and this has been used by the United States as part of its efforts to repress drug smuggling activities. And Professor James Prasker referred to the fact that a fire scout, this uncrewed aerial vehicle, was used in the context of locating a vessel that was suspected of being involved in drug smuggling, providing the signal that it needed to stop, and then waiting until Coast Guard officials were able to arrive. So when we're thinking about how these provisions apply, Article 111, subparagraph 5, does refer to the fact that the right of hot pursuit is exercised only by warships or military aircraft or other ships that are clearly marked and identifiable as being on government service and authorised to that effect. So that is something that we are going to need to consider quite closely in operationalising maritime autonomous vehicles for maritime security policing purposes. Have they been clearly marked, and are they identified as being on government service, and are they authorised as such as well? So these are going to be matters that the international standards need to be incorporated into domestic operations. But there are other elements that we also need to think about. Most particularly, maritime autonomous vehicles are going to be very important, are already very important in relation to intelligence and surveillance functions. And that's appropriate when we think about how the right of visit is done when there is a reasonable ground for suspecting that a certain activity is underway. Or equally, the right of hot pursuit requires that there is a good reason to believe that the ship has violated laws and regulations of the coastal state. So in that particular context of those provisions, we're anticipating that there is going to be intelligence and surveillance undertaken. That's a necessary part of exercising these particular rights, and they could certainly be done by maritime autonomous vehicles. But how much more can a maritime autonomous vehicle do? In relation to the right of visit, when we think about the different stages that's involved, as you're probably aware, one of the next steps that would be involved when we have a reasonable ground for suspecting that an illicit activity has happened is that we need to verify the flag of the suspect vessel. And it is possible, potentially, that the maritime autonomous vehicle will be able to gather sufficient information, relay that to authorities located on land to be able to start a process of verifying the flag. But once we start getting to examining on board or potentially arresting vessels at sea, then we start to think about, well, what's the distinction between what is essentially human dependent in these obligations versus what is vessel dependent in these obligations, that distinction I mentioned at the outset. Similarly, in relation to the right of hot pursuit, we can foresee them and are actually already seeing that maritime autonomous vehicles can be used for hot pursuit. It fits within the terms of Article 111 to the extent that they may be able to give the necessary signal to stop. And also we know from Article 111 that there can be continuous pursuit where perhaps an aircraft gives the signal and starts the pursuit, and then it's taken over by a vessel at sea, which is essentially what the Fire Scout did that I mentioned in the previous slide. But we also get to that point where a vessel needs to be stopped and arrested potentially. And there, if you have an autonomous vehicle, well, who's going to do the arrest in that situation? So perhaps the technology will catch up in this regard and these questions will go away, but we do probably need to think a bit more about this transfer of authority that happens between maritime autonomous vehicles and those crewed ships that are involved in policing operations. When we look at policing activities under other multilateral treaties, we can look at the boarding provisions that you find in the 1988 Drugs Convention in Article 17, and also Article 8 of the Migrant Smuggling Protocol. And the right of visit as it's set up under those treaties is similar in some respects to Article 110. So we're looking for a reasonable suspicion. We also need to ensure that the maritime autonomous vehicle is clearly marked and identifiable as being on government service. We can again perhaps anticipate that they'll be used to seek clarification as to the nationality of the suspect ship. But at some point, humans will likely need to be involved at the current stage. But what's also relevant under these multilateral treaties is to look at some of the duties of cooperation, especially in relation to information sharing and also in relation to capacity building, where there's references to using technology and to sharing information. And this is going to be quite relevant for the use of maritime autonomous vehicles and cooperative efforts that need to be undertaken when we're responding to maritime crime at sea. But let me flip to the other side and think about the fact that it's just policing authorities using maritime autonomous vehicles, but we also have to expect that criminals will do so as well. So in this regard, we have perhaps two scenarios that we should bear in mind. So you'll see in the top image here, there is one of the prototype cargo ships that has been tested. And you can imagine that there may be a maritime surface ship, such as the IMO is dealing with, that 80% of its cargo is legal cargo, but perhaps it does have drugs on board. So what is going to be the situation when you need to stop a maritime autonomous surface ship and potentially undertake a right of visit? This is then humans undertaking the visit in this context. When that vessel does not have a crew on board, what is going to be the process for getting flag state permission to board that ship? How do we, as a practical matter, transfer the operation of that ship in such a way that the policing authorities can board and undertake the inspection? Realistically, at the moment, it might be that this has to happen at port rather than at sea. Then, of course, we have the situation where we're going to see the development of are seeing the development of small maritime autonomous vehicles that are used for smuggling illicit goods, whether it's drugs or arms or other small items. We know, of course, that the drug industry being one that brings in a lot of money, we know that they are early adopters when it comes to new technology. So we have to anticipate that particularly they'll be interested in some of the underwater submersible vehicles that could be used to smuggle goods. And that starts bringing up a host of questions. Will they actually be registered to a particular state? Probably not. Do our rules relating to stateless vehicles or stateless vessels then apply in that particular context? And then, of course, we have questions about, well, what happens when we encounter a criminal MAV at sea? What can be done by policing authorities in that situation? And again, perhaps there's really just a practical response that we're going to talk about in this context, where it may not be essential to really seize the vessel and hold it, but rather we're going to focus far more on disruption by simply destroying the maritime autonomous vehicle and its cargo. There's going to obviously be considerations about whether it's worth seizing the criminal MAV and its cargo and taking it back for prosecution. If you can locate a person that you are going to be able to prosecute, do you need to then extradite them? So the reality is it may just be more in the public interest to just destroy whatever it is that you have found. Certainly there would be environmental implications there, but law enforcement officials take that into account to varying degrees in their decision making. But this also prompts consideration around the use of force that gets used for law enforcement purposes. And we know that it needs to be necessary and proportionate. But our considerations of humanity that we might normally apply in relation to the use of force for law enforcement operations are going to be inapplicable, it would seem, when you're dealing with a criminal MAV that does not have any humans on board. So there are no lives necessarily at stake, and we're probably going to be more likely to be confronted with situations of evasion rather than a criminal ship obeying orders to stop. And that, again, might prompt greater uses of force, and there's going to be a need to consider what sort of rules of engagement are appropriate in this circumstance. Also, in relation to the criminal use of maritime autonomous vehicles, are the considerations as to what sort of offences are really being implicated here. So we can take the example we've seen of the Houthi rebels who have used remotely controlled explosive boats in attempt to attack various ships off Yemen's coast. And in that particular situation, we can see that in that situation, the SUA Convention could potentially encompass maritime autonomous vehicle and its definition of a ship. And when we think about the particular acts involved, we can see that Article 3 of the SUA Convention could also potentially cover these actions. But what's really important here in the end is the fact that we need to ensure that the national laws are aligned as they need to be. We're going to have to think fairly carefully about crimes of participation, think about crimes of facilitation or crimes relating to aiding or abetting, and how will that play out in different scenarios, whether it's under the Sewer Convention or with Rob McLaughlin. We have come up with a scenario where you can see a wide range of actors who are potentially implicated in a scenario involving a criminal MAV, and we're going to need to tease through those sorts of jurisdictional issues, not only as a matter of international law, but also in how we're implementing those conventions in our national laws as well. Now, just to finish quite briefly, I imagine I'm almost at time, I just wanted to signal that obviously maritime autonomous vehicles beyond our policing type scenarios is going to be very relevant for other maritime security situations, especially defence situations. This gives you an indication, the picture on this slide, of the variety of vehicles that are deployed. At some point, we're going to be talking about maritime autonomous weapons, and there are, of course, a host of considerations about the use of that kind of weapons for international humanitarian law. And as I mentioned, the question about whether maritime autonomous vehicles are warships or not is significant, and one of the aspects to remember here as well is that it is a warship that has belligerent rights under the law of naval warfare, whereas a naval auxiliary only has rights of self-defense rather than belligerent rights. So again, that distinction about what is a warship or not will be relevant in that context. And of course, as I mentioned, intelligence and surveillance and reconnaissance are going to be and are currently the critical uses of maritime autonomous vehicles. And I showed you the picture previously of the glider of the United States that was seized by China, but of course it's not just the United States that's using this sort of equipment. So Indonesia recently recovered a Chinese glider that you see here. Do you think that's a ship? That was involved in reconnaissance around Indonesian waters and spotted by Indonesian fishers. So once we start talking about intelligence issues beyond the strategic considerations, we're going to have to make this decision about whether they're ships or not. What's their ownership status? Do they have the freedom of navigation similar to other ships? And then we have all the complicated questions that we deal with in relation to intelligence gathering more generally, and that seem to be applicable to maritime autonomous vehicles in terms of defining what's marine scientific research or military research, and then thinking about the implications for our different passage regimes. So there are no shortage of questions. So my colleagues and I have been exploring what all these key questions are. That is the first stage of our project. The second stage is to try and provide some answers. So hopefully in any future presentation, I'll have some more answers than questions raised, but hopefully you get a sense of many different issues that this new technology is prompting at this point. So I'll leave it there and look forward to the discussion. Thank you.
Thank you so much, Professor KLEIN.